Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to our beloved lecturer, Madam Siti Nur Najwa binti Mustari. Thanks for joining us. Thanks for joining our seminar. And today, we would like to talk about our chosen topic in industrial relation, which is unfair dismissal. We would like to introduce ourselves first. My name is Muhammad Lukman Hakim Mazli.
My name is Muhammad Haikal bin Kamaruzaman.
My name is Shakir Zufairi bin Muhammad Saifuddin.
My name is Anis Shakila binti Hilman.
And my name is Nasuha binti Azlan. For your information, one of our member, which is Mr. Muhammad Rahman Firdaus bin Abdul Wahab, cannot join this seminar. Next slide.
Okay, for the introduction, before terminating employees, Malaysian employment law requires employers to have cause and reason. Worker safety in the workplace has been equated with rights by the courts. Employers, on the other hand, are all too often unaware of something like this. Likewise, most employees are ignorant that they have a right of protection to protect themselves if they are fired unfairly, and they are aware of how to protect themselves and other employees. Termination of an employment contract for unjustified cause. The company will send the employee a letter that is a termination letter. An employee who does not follow the law, on the other hand, cannot dismiss an employee purely on the basis of compliance with the notice time provided in the employment contract, which has been agreed upon by all parties. This assumption is incorrect, and if the employer makes it, it will be to his disadvantage. However, if an employer wants to lay off employees, they must have powerful argument and evidence to back up their decision, or he may suffer individual and commercial disadvantages. As a result, termination must be justified by factors such as gross misconduct, a lack of skill and qualification, inability to complete assigned tasks, and redundancy. Moreover, an employee who believes he has been wrongfully terminated by his employer without cause or explanation has succeeded from the date of the employee is attempting to return to his or her previous position with the employer by submitting this representation. But this action can only be taken by an employee who believes he has been fired unfairly. However, if both parties are unable to reach a deal through discussion, the matter will be referred to the Minister of Human Resource, who will determine whether the delegation is suitable for referral to the industrial court. Below are the reasons of the topic come up. First, employer does not have a good reason for dismissing you. If your employer does not follow the company's formal disciplinary or dismissal process or the statutory minimum dismissal procedure in Northern Ireland, situation when your dismissal is likely to be unfair is include if you requested for flexible job but the request is not succeed. Sometimes your employer's refusal will be perfectly reasonable and valid because your request has been considered carefully and reasonably, and it simply is not possible to accommodate the change you have asked without any negative impact on the company. Don't forget that your right to work flexibly and your employer's right to manage their business must be balanced. Second, manager refuse to give up your working time right. Next, unfair dismissal can come up if you got dismissed when your manager refused to give up your working time right. As example, to take rest breaks and overtime issues. You might feel managing ask hours. On top of you only have the extra hours would make you earn less than the national minimum wages. You can also check what a reasonable amount of overtime in your contract. Last, this method also come up when you were forced to retire, which is known as compulsory retirement. An employee cannot claim unfair dismissal if the employee is at the normal retirement age for their job with the employer, as this will be an automatically fair reason for dismissal. However, when there is no retirement age, an employer can no longer dismiss an employee based upon their age. They also need to notify the employee of the date on which he intends that employee should retire and inform the employee that they have a right to request to work beyond retirement age. Compulsory retirement is not allowed unless your employer can objectively justify it, but you can challenge it at an employment tribunal later. An employer's compulsory retirement scheme requires the dismissal of an employee for no other reason than the employee has attained a specific retirement age. The retirement age may be fixed in the term of the contract of employment, a staff handbook, a collective agreement, or other regulation that determine the rules governing a particular retirement age. For the procedure of the topic, there are four procedures. The first procedure, they need to try to resolve they need to try to resolve the reason. Employees and employers can also resolve problems through conciliation through the labor relation agency, as they can help with problems faced by employees. After 3 months of dismissal, the employee must make a claim to the industrial tribunal if the employee is a worker or member of the armed force, self-employed person, an agency term working under a contract for service, chef fisherman, member of the police service, and exempt from the unfair dismissal provision by an order made by the Department for the Economy. Employees can't make complaint. Secondly, an employee cannot make a complaint about unfair dismissal if the employee has entered into compromise agreement with the employer. For example, when the employee has agreed not to make a complaint about it to the industrial tribunal. When an employee enters into a compromise agreement with the employer, the employee should seek independent legal advice. If the employee is successful, the industrial tribunal will favor the employee. The ordinary employee is given compensation. For example, the employee is given the opportunity to return to work. Employee Employees doesn't have to take your job back, but your compensation may be lower if you don't. Compensation is intended to put you where you would have been financially that you had not been sacked. There's no compensation for hurt feeling, except if you have also successfully claimed for unlawful discrimination. You will be expected to minimize any financial loss by claiming benefits from your local jobs and benefits office or look for a new job. Third, going to an industry tribunal. It is another option for dealing with unfair dismissal. If you wish to file an unjust dismissal claim with an industry tribunal, you will usually require 1 year of service first. You can file a claim if you were fired for an automatically unfair reason, regardless of how long you work for your employer. The chosen industry tribunal is the first court to hear individual issues pertaining to employment or apprenticeship contracts between employers and workers or apprentices. The chosen industry tribunal is made up of professionally elected judges as well as an equal number of employers and workers. If there is a vote, the final judgment is made by professional judge. Lastly, in some cases, you may be able to make an application to an industrial tribunal for interim relief if you have been dismissed. If the industrial tribunal believes it is likely at your full hearing that your complaint will be successful, it may order. Returning to work is one of the sorry. Returning to work is one of them. The implication is that you should be treated as if you have never been dismissed. The next step is re-engagement, which means that you should be re-employed but not necessarily in the same position or under the same term. The final option is a temporary extension of your employment contract, which means that your employment will continue until your claim is resolved. Next slide. For the type of topic, I will hand this slide to Miss Anishakila bin Khaiman.
Thank you, Mr. Muhammad Hakim. Okay, now we present about the types of unfair dismissal. Firstly is compensation. Related to the compensation is usually built up from two components, which is basic award and compensatory award. Basic award usually not related to loss suffered. It is actually a weekly payment. The basic award usually will refer to the age of the applicant and the years of service. However, if the long service workers has dismissed an earlier stage that will include in this method is 20 years old. But 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 this has exception workers who below 16 or after 65 years old. Nowadays, many awards that including the basic award are related to the inflation. Secondly is dismissal on ground of industrial action. This is unfair dismissal. This is the unfair dismissal way dismiss the workers because taking lawfully organized officially industry action for 8 weeks or less. This action was started on after 24 April 2000. It also being an unfair dismissal for dismiss the worker who have taken the action for 8 weeks. If the first action taken by employer, it can be relevant causes to the dismissal. The employment tribunal was reasonable to determine whether the employer had taken the actual step to do it. They also need to will regard the action that have been done between employer and union. However, an employee tribunal did not have any power to determine any issue about unfair dismissal when they take a part in industrial action that provide the worker employer. But at the same time, have some able solutions such as the employer has dismissed and all workers who have involved to the action but because they are to make same complaint about the date of their dismissal, and the employer did not propose any re-engagement within 3 months of the date of their dismissal without taking the similar of. And thirdly is dismissal in connection of criminal. In a case where an employee is suspected of committing a criminal offences, the real question is whether the employer genuinely believed the reasonable ground of the applicant was good worthy of the offences is questioned, rather than the whether the employer is guilty beyond all the reasonable doubt. As in criminal court. In this case, belief or reasonable grounds will most be involved in real investigation on the part of the employer. So, if the employee is clearly guilty by a criminal court of the offences, the question in question. If employers conduct such inquiries and give the employer an opportunity to explain what happened and then has reasonable ground for concluding that the employee can no longer be retained. The tribunal was usually find that employer acted reasonably. If the employer dismissed the employee without making suitable inquiries or giving the employee an opportunity to explain, the tribunal may conclude that employer acted unfairly and that the dismissal was unfair. Next slide. Okay, so the next point will be proceed by Ms. Nasima.
Thank you, Ms. Anishakila. So I will proceed with the analysis of three cases. For the first cases, it is between Chan Yong-san and Gamudalan Sunjam Berhad. So the claimant, which is Chan Yong-san, had been constructively dismissed by her company, which is Gamudalan, and the dismissal was happened without cause or reason. After that, she worked with Valencia Development Sunjam Berhad, which is a subsidiary of Gamuda Berhad and is under the same Gamuda group of company as the company herein as a secretary. And according to the claimant, every time Gamuda Berhad starts on a new project, it will be established to carry out that project, such as for new Gamuda Cove project in Dengkil. Next, the claimant informed that she will be transferred to the company site office, which is Gamuda Cove based in Dengkil, and pursuant to the transfer, the claimant would now be reporting to Wan Wong Yik Fong, who is the company's general manager. However, the site office in Dengkil was not ready to operation, and thus the claimant was based in Menara Gamuda, Damansara Perdana. The claimant claims to have objected to this transfer since it would cause her to undue hardship and burden due to the considerable commute distance between her new office in Gamuda Cove and her apartment in Rawang, which is 60 to 70 kilometers per day and will take between an hour and 90 minutes to commute. Moreover, the claimant further argues that her work nature, duties, and functions are significantly different as a result of the move, and that she considers this as the company's attempt to undermine her position by effectively demoting and humiliating her, resulting in her resignation. So, the company had also breached the fundamental conditions of the claimant's employment contract with the company, including express and implied terms, entitling the claimant to constructive dismissal. Next slide. So I will pass the second case to the next presenter.
Thank you, Mr. Suha. Okay, now I will present about the second case, and it is between Muhammad Azhar bin Abdul Halim and Nazar Motor Trading Sindiran Berhad. Okay, the company receiving an email from her female employee, in bracket COW1. It started that the claimant have threatened her and scared her and made her leave the company as she was not comfortable to work since, uh, since the claimant was around. Then the claimant replied about the issue first and suspension later was not acceptable. In case of that, the company then issues a dismissal later to the claimant is as it not shows the threatening and harassing act toward the COW1 as major misconduct that caused the claimant was dismissed from the company. A year before he dismissed, the claimant undergo probability period for 6 months. During the period, he was apprised and was given a warning letter. The company asserted that claimant dismissal was with just cause and excuse. Based on the criminal letter, he requests that company provide him with more information about the police report field, the name of the complaint, and the allegation of purportedly threatening and harassing work and causing an unconducive working environment and threatening words or bodily harm perception as a safety and security compromise. The claimant claimed that his letter to the company amounts to a valid notice or additional document from the company and its exercise of his meaningful right to be heard, which the company had failed denied. Furthermore, the claimant started that purported content of the assault was blasted and just like of fact that the company and the COW1 made. However, the claimant confessed that he had a personal relationship with COW1 during the entire time was great. At that time, COW1 did not show any bad expression such as scared, depressed, and threatening feelings toward the claimant. The claimant claimed that after receiving such complaint from COW1, the company apparently behaved fairly. Sorry, the company apparently behaved unfairly and lawfully by rejecting him, acting without justification and reasonable toward his interest by acting on unconfirmed and unsubstantiated evidence without valid ground dismiss him. Lately, the claimant start to evidence that him show the showcase and suspension the company. Sorry. Lastly, the claimant started evidence after the showcase and suspension letter was issued to him by company was never called off or given any opportunity by company to give any explanation. In fact, the company did not provide the claimant with the necessary papers or facts enable him to respond to the allegation made against him in show cause and suspension later despite him the best effort. Okay, next. Will be proceed by the next presenter.
Okay, thank you, Miss Anis. Okay, the third case, which is Ong Chen Hun and Guasera Sendirian Berhad. Okay, the claimant claimed she was then ordered to sign a notice of rearrangement without being given the time to think about it or seek advice. That she was then instructed to travel to the company human resource department to collect her income tax document before leaving the premise. She mentioned that her termination is without any reason and unfair labor practice. Second, various functions across the Guasera group of company, including the claimant, were identified as a superfluous. In about 248 employees being restructured since their position were eliminated and their function no longer existed in the organization. According to the company, at the same time, claimant job include managing gallery operations, selling product to customers who visit the gallery, and identify employees who are access to the company workforce need. The company thought that their decision was right to terminate and surplus employee. Besides that, claimant dismissal was because of the retrenchment exercise carried out by the company. The retrenchment referred to any flaw in the produce that could lead to the employee claiming an unfair dismissal lawsuit. Next, recommendation of case one, I will give to the next presenter, which is Ms. Nasuha.
Thank you to the Mr. Haikal Kamal Zaman. So this is the first recommendation of case one, which is discussion with the employer. All right. Leaving the work should be the very last option when it comes to constructive dismissal. If someone wish to quit their work due to their workers' action, an option to handle the problem of constructive dismissal is to communicate with the employer directly. This is because when an employee and employer have a talk, they can determine the source of the problem and discuss in a productive and mature manner in order to find a solution to the problem. Moreover, employees should speak with their employers with appropriate manner and language, since if they are nice and humble, the employer will discuss the matter properly without having to deal with other parties like the court if the discussions fail and no solution can be found. Furthermore, It is important to admit both parties' wrongdoings throughout the discussion, as this will make it easier for them to find a solution because they need to know what is the problem causes that can make an employee can be constructively dismissed. This problem must also be clarified as to whether the offender was the employer or an employee in order to avoid the problem becoming worse and more difficult to resolve if the problem has already been convicted in court that can cause one of the parties to suffer loss. So the next recommendation will be presented by Mr. Shakir Zufairi.
Okay, thank you, Ms. Nasuha. The next recommendation is ensure employer agreement. Work must ensure the employment agreement covers certain important conditions. For example, by including the terms that authorize and contemplate transfer, change in duties, or change in pay structure at the beginning of the employment relationship can help to protect them against constructive dismissal claims. Before making any change to the work relationship, they should speak with an employment law or a human resource consultant to verify your legal obligations are met and to avoid any potential constructive dismissal claim. I will pass the next presenter.
Okay, thank you, Mr. Shakir Zufairi. Okay, now I will give a recommendation for the for the second case. And the first recommendation is improve overall performance. There are many recommendations to avoid misconduct. The first recommendation is improve overall performance. One of the most obvious advantages of frequent evaluation is the change to improve overall workplace performance. Taking the time to examine your staff work over the past year or whatever time period you want is an excellent way to identify areas that require improvement. When feasible, and analyzing problem and finding solution might help to avoid the need to hire a new employee. As a manager, you may assist your staff in developing benchmarks for measuring development and setting deadlines for each level of performance. If the performance is serious, sorry, if the problem is serious, you may need to place a staff member on probation until the situation improves. Providing a financial incentive, on the other hand, may provide further encouragement and speed up the process. You can also identify training needs. You, your new hires will almost certainly go through training when they are initially recruited. But workplace learning does not end after boarding is over. Whether you install a new system or different approach, your employees will not most likely require further training or sometimes during their career with your company. If several staff members are suffering in the same area, it is possible that they are not doing well by purpose. There might be a lack of proper structure in a place to assist them in learning the ropes. True, workers may bring up subjects in which they need extra training on their own. Among the most reasonable methods to ensure your employees are properly onboarded is to conduct frequent performance review. This method may assist you to identify areas where the new hires should receive further training or where the experienced employee should receive fresher training. So the second recommendation for the second case will be proceeded by Ms. Shakir Sufai.
The second recommendation for the second case is get a feedback from the team. The best way to get an honest feedback from your team is to create a culture of open and honest communication. To do this, start by showing a genuine interest in how your people are doing, what's causing the problems, and how you can help. Ask a question that will help you gauge how your employers feel about the environment, workload, and productivity. For example, the employer asks about the employees' duty. For example, how is your project coming along? What's going well? What's stopping from you from reach this goal? This will help employers determine when and where you need to offer more support and when you need to back off. Employer can also ask a specific question about employer and about employer performance as long as you don't come across as an egomaniac and conversely someone who needs constant reassurance. Misconduct is being honest with your employer is the most efficient way to motivate yourself to them and acquire the trust. It includes conceding to your flaw and starting I'm sorry when appropriate, being upfront and honest with yourself about how you can encourage your colleague to converse more easily. I will pass to the next presenter.
Okay, thank you. Wait. Okay. The employer must give notice to the employee for 60 days prior to large-scale employee layoff. Employer need to inform employees who wish to be retrenched whether their retrenchment is permanent or temporary, and if the latter, how long is the expected period. At, at the same time, the employee should inform the employee of the expected date of separation. Employer should inform more clearly about outlining the process to obtain the right to withdraw and apply for position in the future with other companies. Second, some countries have enacted mini one. They extend the notification requirement to small business commitment layoff. Reviewing state law will be important, given that the mini one acts often impose additional conditions that are different from federal law. Next. Okay. Recommendation of case 3 will be handled Mr. Shaki. By Mr. Shaki.
Thank you, Mr. Haikal. Inform workforce of layoff. Unfair dismissal is informing the employer to be dismissed. The employer may also want to communicate the firm financial situation as well as commit to attaining corporate goals and objectives in the future to the present employers. Many of the employers addressed by the employer had formal deep connection with the layoff coworker and they will be curious about their future with the firm as well. Notifying the remaining workers of the layoff will assist to put an end to any rumors. Thank you. I will pass to the next presenter.
All right, thank you, Mr. Shakir Zufairi. So we have done analyzing the 3 cases and also the 3 recommendation of the cases. So as a conclusion, unfair dismissal was an error made by a company or a manager. It was an error that need to be avoided. It is because it has the potential to have a significant impact on both the company and the employee. For example, if an employer has been fired without reasonable cause, the matter may be taken to court. The procedure of resolving the issue will take a long time and require at least a significant amount of money. It leads to a lot of court procedures costing a lot of money, such as lawyers' fees and the money they have to pay if they lose the case. From our research, we have identified that have various of issues that can happen that related to the unfair dismissal and constructive dismissal. Sorry, that happened between Chan Yong San and Gamuda Land, Sendirian Berhad, misconduct that involved between Muhammad Azhar bin Abdul Halim and Nazar Moto Sendirian Berhad, and unfair dismissal that happened between Ong Chang Hon and Go Sarah Sendirian Berhad. As a good manager, they can make unfair dismissal to the employee. They need to make the right decision before they dismiss the employee. They also need to make sure that they follow the actual procedure to dismiss the employee to make sure the dismissal can be done fair between employer and employee. So that's all from us. Thank you.